GettyA court case against Theresa May's triggering Article 50 has been thrown out. The case claimed Parliament had not made a constitutionally valid decision indicating the UK had chosen to leave the EU. This would mean the government did not have the authority to strike an exit deal with the bloc. However, Deputy High Court Judge Mott QC said Article 50 had been triggered in accordance with the Supreme Court decision on the Gina Miller case, and the new claim had been submitted much too late. The judge ruled that Ms. Miller's case, which concluded in January 2017, had set out the method for beginning Britain's formal exit from the European Union. He believes the government followed this ruling. Mr. Mott read the triggering of Article 50 was authorised by an Act of Parliament which appears to meet to comply with the Miller decision. Even if the claimant is right and it does not comply, it is much too late to challenge it now. The court case was filed on October 23, 2017, 7 months after Theresa May wrote to the European Union to formally declare the UK's intention to leave the bloc. Mr. Mott also said the process of negotiating an exit deal with the European Union was ongoing and should not be challenged at this stage. Gina Miller's court case decided how Article 50 could be triggered. Hay said any claim relating to the arrangements for leaving the EU is at present premature. It is not yet clear whether Mrs. May will negotiate a free trade deal with the EU or whether Parliament will vote on any withdrawal agreement. Although a constitutional invalidity could arise in the future as a result of the Brexit withdrawal agreement, this would need to be challenged as and when it appeared, rather than in a theoretical sense. The claimant must now pay £1,352 in legal costs to the Brexit Department. Twitter, a case claiming Article 50 was never triggered, has been refused. Twitter, a case claiming Article 50 was never triggered, has been refused. The case was won in a slew of legal challenges focusing on the validity of Mrs. May's triggering of Article 50 on March 29, 2017. Another such case, led by a Lib Dem parliamentary candidate and backed by Professor A.C. Grayling, has raised more than £130,000 in crowdfund pledges. However, the refusal to hear this legal action is likely an omen for other Remainer challenges. The government had invited the High Court to dismiss the case as totally without merit, which would have given the claimant no recourse to take their argument further. However, although it refused the case, it was not thrown out in this manner. The claimant will therefore be able to challenge the refusal at an oral hearing in around 1 month's time.